Good morning, everyone. We have a beautiful weather. Today is Wednesday, March 29th, so already March is gone. All right, this morning we're going to talk about one of our legal issues, will and descent. Looks like we're going to talk about someone dies. When someone dies, what will happen with will or without will, and also some other situation. Okay. First, basically in this seminar, we want to pick up some vocabulary. Okay. So basically that's it. If we know the vocabulary, the meaning of words, then we are okay, because we are not attorneys, right? So we are mostly general public and real estate agent, etc. We are not attorneys. The first case is if someone dies, when someone dies. Okay, a different situation can be different situation. First case would be the deceased person. Deceased means a little bit different expression of dying. Okay, same thing. Died, passed away, deceased, basically is the same meaning. So the deceased person dies testate. That's what we want to learn today. Testate means he or she leaves a will. Okay, that's the case. Testate. What about the other case? Opposite case. Someone leaves without a will. Okay, let's do a preview. In that case, we call someone dies intestate. Okay, so someone dies testate or someone dies intestate. So someone dies testate means he or she leaves a will. Okay, so let's talk about this case first. The deceased person dies testate. So there is a will. So party making the will is a testator. Okay, so before someone dies, he or she will be a testator. Someone will making the will. Well, somebody else making will for you, I guess that's possible. But there's some legal process has to go through. So anyway, the party making the will, we call testator. And also in the will, there will be an executor. Okay, so will always have the name of executor. So this executor will be responsible for carrying through the whatever content in the will. Okay. And the legal title is subject to the control of the probate court. So we're gonna pick up probation. Probation is a legal process of determining the validity of the will. Okay, so most of us, we know what the will means, but probably the testate is not a familiar word, but we know now. Okay, so with will someone dies, then we call he dies or she dies testate. And the party making the will is testator. And in the will, usually there will be an executor. So executor is the person who will be responsible for carrying through and the performing all these contents in the will. Typically, executor can be the the deceased person's relative, the trustful relative also. Anyway, if you died testate, then there will be a court session called the process of the court performance would be called probation. Okay, so probation is a legal process of determining the validity of the will, and the decedent's real property passes directly to the beneficiary on the will. But of course, we have to go through a probation process. Okay. But sometimes this probation becomes an issue. And sometimes it takes time, even though you die testate, because you have to go through this probation. So when you deal with estate property, someone says, okay, that the owner of that property died, and this is an estate. If you see any estate in the listing information, or someone told you this is estate, means the owner passed away, then you have to check whether probation is completed or not, because during the probation process, you cannot sell the property. All right. But after all, of course, the real property will go to beneficiary on the will, but it has to go through probation process. One note we need to make is, this is kind of important because I experienced, because of this rule, or the law, basically it's the local law. We had a deal canceled, terminated. Okay, let's see what's this note said. If descent is a resident of New Jersey, the will should be filed for probate with surrogate court of the county where the descent resided, regardless of where in the state the property is located. Oh, so, well, if someone died, if someone lived in New Jersey, and that person's property is located in New Jersey, I guess no problem. Okay, then the executor can go to the pertinent county where the descendant resided. But sometimes there could be investment property, right? And if this investment property is in, for instance, other county or other state, still the probation process has to go through the county court where the descendant resided. Okay, in that case, if it's out of county or out of state, in this case, we call the let's say Bergen County, someone resided, but we're dealing with the investment property in, let's say, other county or other state. Okay, so the probation process has to go through surrogate court of the county where the descendant resided, not the county that the subject property is located. Okay, but it's kind of confusing, right? Without this knowledge, You know what? Even at the time, the attorney involved, attorney was the seller's attorney, and that attorney even didn't know this local law. So he really followed up, and because the older lady passed away, but she lived in New York State. Okay. And this attorney didn't know. This attorney filed a probation process in New Jersey. Right? You know what's the problem right now, right? This seller's attorney should file the probation process in New York because the older lady resided in New York. So you understand now, okay? So it was a messy, and the general situation is New Jersey probation code relatively fast, but New York probation code, forget it. It takes forever. So because it took even more than 6 months, so during that time, basically deal was canceled. Even further, this seller's attorney really messy. He didn't want to return the buyer's refund money. So, and this buyer had to hire some the powerful attorney, and in this case, even the seller's attorney can be in trouble because the seller can sue this attorney because this seller's attorney didn't know this is a simple rule. He didn't know. He was not aware of, I don't know, or careless. He should have filed the probation in the New York State, not New Jersey, Bergen County. So that's basically a tested case. What about intestate case? Someone dies, the deceased dies intestate, means he or she leaves no will. In that case, instead of executor, in this case, there should be administrator is appointed. Okay. And the then real property will pass to the descent heirs by the state law of descent. So if there is a will, it's relatively easy because will specifies where to go and how much it will go, etc., to whom, etc., beneficiary. But without will, someone died, then immediately the court take over, and they have to apply to state law of descent. Well, law of descent, in general, law of descent, okay, that means there's a lot of different cases, okay? This person died with a survivor or without survivor, with the children, I guess, divorced, but live together. There's a lot of different cases, and law specifies a different portion, yes and no, all this kind of the complicated different cases. So again, we are not an attorney. We are not going to look into law of descent, but we need to know the word intestate means without will. Okay, someone died intestate, without will. And in this case, the court will designate administrator. This administrator will take care of all this, the process. And so eventually real property will go to the descendants heir according to the state law of descent. And the third case, what about the descent dies intestate and no heirs? Okay, so that's dead end, without will, and there's no heirs. In this case, the definition is he or she dies without will intestate, and if there are no heirs capable of inheriting his/her estate. Okay. In that case, the state reverts to the state of New Jersey, whatever the property located. And this process is called escheat. Okay, so someone dies intestate with no capable of inheriting heirs, then the property will go to state. That's what is going to happen. That process we call escheat. Okay, another situation is a will, but holographic will. This sounds kind of weird, but the holographic will is, in this case, unwitnessed will. There's no witness. Will that is written in the handwriting of a person under whose name it appears. Handwriting will. No attorney involved and no witness involved. But interesting thing is, holographic will is valid in New Jersey. However, the failure to seek professional assistance in preparing a will may result in disagreements and litigation later on. Well, someone dies and the family found a holographic will, something on the napkin or at the hospital room, right? And then problem is okay, it's valid, but if the family members are all fine and good people, it's okay. But someone can disagree, and among the family members, someone can rely on the legal action. So it can be very complicated. Again, we are attorneys, but we know a holographic will is valid in New Jersey. Okay, what about the other case is a trust? Okay, a trust is an arrangement whereas legal title to property is transferred by the trustor to a person called the trustee. Okay, so someone who has a real property and close to very old, aged, then he can make or she can make she can be a truster. Okay, property owner can be truster, and the truster can appoint trustee in this trust arrangement. Okay, so trustee will take care of, will be responsible for arranging and a process, whatever something happens. So real property is held and managed by trustee for the benefit of the people specified in the trust agreement. We call those people beneficiaries. So trustor will appoint a trustee, and trustee will be responsible for the managing and arranging for the benefit of beneficiaries. Okay, so we just pick up a few words. Once we pick up some words, then we become very intelligent. And I don't know the pronunciation is correct, but inter vivos or vivos trust, inter vivos trust, is a trust established during lifetime of truster. Okay, this older lady who has a lot of money, she is a trustor who made the trust, an appointed trustee. So during the lifetime of a truster, there is a trust established. In that case, we call inter vivos trust. And the other concept is testamentally trust. A testamentally trust is a trust set up by will and effective upon the death of the trustor. So then I guess will and trust is kind of similar. Okay? But again, we are not attorneys. We don't want to get into the true legal differences. But as far as I know, trust, it has a more we can specify elaborated the way of distributing the properties. Okay. And so again, there are about 5 different cases. One is testate, and the other one is intestate, without a will, and intestate and no heir. It's basically the property goes to state. We call that escheat. And holographic will is valid in New Jersey. And also the other type of distributing the property is trust. That there is a trustor and there will be trustee. Trustee will be responsible and managing the property for the benefit of beneficiaries. Okay, and the intra vivos trust is trust established during the lifetime of trustor, and testamental trust is will be effective upon the death of the trustor. Okay, 오늘은 우리가 죽었을 때 someone 세상을 떠났을 때에 유언을 가지고 죽은 상태를 유언이 있는 상태로 돌아가신 경우를 testate이다, dies testate이다 이렇게 표현을 하고요. testator는 will을 쓰는 사람, 만드는 사람. 다른 사람이 될 수도 있겠죠, 그죠? 변호사의 배하에. The will specifies an executor. will이 있는 상태에서 돌아가셨을 경우에는 executor가 임명이 되고 그 executor가 이제 probation 과정을 다 책임지고 처리를 해준다. 대개 executor는 가까운 친척이 될 수도 있다. 그리고 이제 그 validity가 증명되면, 즉 probation 프로세스가 끝나면 재산은 그 beneficiary한테로 넘어간다. 그런데 주의할 점이 하나가 이 probation 프로세스는 그러니까 will을 가지고 돌아가셨다 그러면은 이 estate를 처리할 때 반드시 probation이라는 걸 거쳐야 돼요. 그냥 아무 코트 없이 will이 있다고 그냥 재산이 넘어가는 게 아니고. 그런데 주의할 점은 이 probation은 반드시 어디에서 해야 되냐면 그 돌아가신 분이 사는 거주지의 카운티에서 하셔야 돼요. 만약에 프로퍼티가 다른 카운티라면 이때 이 돌아가신 분이 살고 있었던 카운티는 서로게이트 코트라고 해요. 네? 그래서 실질적으로 이제 할머니 한 분이 돌아가셨고 그 인베스트먼트 프로퍼티를 시장에 내놓고 팔으려고 하는데 리스팅도 굉장히 큰 브로커 컴퍼니였어요. 유명한 컴퍼니예요. 근데 그러한 것을 디테일한 거를 물론 이제 어터니가 핸들하니까 전혀 몰랐고 이 리스팅 브로커도 굉장히 유명한 브로커예요. 근데 요 심플한 걸 몰랐기 때문에 이 셀러 어터니가 프로베이션을 뉴저지에다가 버겐카운티에다가 파일을 해놨어요. 알고 봤더니 이 돌아가신 할머니는 뉴욕에 살고 계셨어요. 오케이? 그러면 이 경우는 뉴욕에 그 할머니가 살고 있던 카운티가 서로게이트 코트가 되면서 거기도 파일을 해. 오케이? 그걸 몰라가지고 이 셀러 어터니가 버겐카운티에다 떡하니 파일을 해놓은 거예요. 그러니까 한참 지나가다가 이제 다시 빠꾸라고 그러죠. 그러면은 리턴해버리고 그 다음에 다시 뉴욕으로 가니까 뉴욕은 또 이 프로베이션이 엄청 오래 걸린대. It takes forever. 그래서 결국은 이 바이어가 캔슬했는데 더 엉터리인 것은 이 셀러 어터니가 또 디파짓을 안 돌려주려고 그래. 그래서 강력한 변호사를 하여해가지고 너 malpractice다. 네가 잘못해가지고 이런 기본적인 어떤 룰에 대한 걸 모르고 또 버겐카운티에다가 프로베이션을 신청해 놓고 나중에 메스가 되니까 이게 어떻게 돼요? 그러니까 사실은 정확하게 하면 셀러는 돌아가셨고 셀러의 친척들이 말하자면 윌이 있었다면 여기 엑스큐터가 이 변호사를 수하면 굉장히 문제가 될 수 있죠. 아무튼 그래서 그런 내용을 강력한 변호사 하나 딱 보냈더니 그 다음 날로 디파짓을 리턴했어요. 참 어처구니가 없죠, 그죠? 그러니까 지금 여러분들은 퍼블릭이시거나 아니면 에이전트 입장에서 이런 거 기본적으로 알고 계시면 좋겠다. 그래서 에스테이트 프로퍼티를 여러분들이 사시려고 하거나 아니면 에스테이트 프로퍼티를 리스팅할 때는 이런 기본적인 것은 체크를 해주시는 게 좋겠다. 자, 그 다음에 윌이 없이 돌아가셨으면 어떻게 되느냐? 그것도 팔 수는 있겠지만 복잡해지죠. 왜냐하면 이 애드미니스트레이터가 지정이 되고요. 그때는. 그리고 모든 게 상속법, 제너럴한 상속법에 의해서 처리가 돼요. 그러니까 그 에스테이트가 온전히 팔 수 있을지 없을지도 몰라. 그러니까 복잡해지는 거죠. 그러니까 이런 프로퍼티, 어떤 분이 돌아가셨다. 그 프로퍼티랜다 하면 이렇게 쭉쭉 몇 가지를 체크해 보셔야 되겠죠. 그런데 이제 흔한 경우는 아니겠죠. 위원장도 없고 상속자도 없다. 그러면 스테이트가 가져간다. 그 프로퍼티는 그것을 우리가 에스치트라고 합니다. 그다음 홀로그래픽 윌은 뉴저지에서 인정된다는 거예요. 손으로 쓴 거 돌아가시기 전에. 단지 이제 노트는 서로 패밀리 멤버가 디스어그리를 할 수 있고 그다음에 수를 걸 수도 있다. 그 사람 이제 왜 그러냐면은 이렇게 글을 썼는데 그 인텐션하고 뭐 사실은 여기 언급은 안 됐지만은 그 소리로 위를 남기는 경우도 있죠, 그죠? 그랬을 때 그 정확한 인텐션이 뭐냐를 가지고 이 법적인 해석이 다 달라질 수 있기 때문에 디스어그리하고 소송이 걸릴 수가 있다 이런 얘기죠. 그 다음에 이제 트러스트라는 걸 만들어서 잘 정리를 할 수도 있겠다. 트러스트에 거기에서 이제 트러스터가 들어가신 분이 되고 그다음에 트러스티를 정해서 그 트러스티가 그 베네피셔리를 위해서 잘 정리를 할 수 있다. 그래서 인터비브스 트러스트는 그분이 살아있을 때에 작성이 되고 테스트먼터리 트러스트는 돌아가신 이후로 작동이 됩니다. 그 윌과 트러스트는 좀 비슷한 성격이 있다. 트러스트가 조금 좀 디테일해서 자세히 여러 가지를 계획을 짜놓을 수 있는 그러한 장치가 있다. 우리는 뭐 변호사는 아니지만 이 정도 알고 있으면 그래도 큰 실수를 저지르는 것을 막을 수 있겠다. Okay, this is it for today's mini seminar. I hope when we deal with the estate, either you buyer or seller or agent, we kind of need to know some basics so that we may not get into big trouble and problems. Thank you all. See you all next week.